During this video, I will discuss what are revocable living trusts. A revocable living trust is a legal document that can, in some cases, partially substitute for a will and a general power of attorney. With a revocable living trust, also known as a revocable inter vivos trust or grantor trust, your assets are put into a trust, administered for your benefit during your lifetime, and transferred to your beneficiaries when you die, all without the need of court involvement. Most people name themselves as trustee in charge of managing their living trust assets. By naming yourself as trustee, you can remain in control of the assets during your lifetime. In addition, with respect to revocable trusts, you can revoke or change any terms of the trust at any time as long as you are still competent. The terms of the trust generally become irrevocable when you die. However, in trusts created by married couples, the entire trust or some portion of the trust may continue to be revocable by the surviving spouse. In your trust agreement, you will also name a successor trustee, a person or an institution that will take over the trustee and manage the trust assets if you become unable to do so. Your successor trustee would also take over the management and distribution of your assets when you die. Your living trust agreement has certain characteristics. It gives the trustee the legal right to manage and control your assets held in your trust. It instructs the trustee to manage your trust assets for your benefit during your lifetime. It names the beneficiaries, for example, the persons or charities or organizations who are to receive your trust assets when you die. It also gives guidance that certain powers and authority of the trustee to manage and distribute your assets. The trustee is a fiduciary, which means he or she could hold the position of trust and confidence and is subject to strict responsibilities and high standards. For example, the trustee cannot use your trust assets for personal use or benefit without your explicit permission. Instead, the trustee must hold and use the trust assets solely for the benefit of the trust's beneficiaries. A living trust does not, however, remove the need for a will. Generally, you would still need a will to govern the post-death transfer to your trust of any assets that were not transferred to your trust during your lifetime. This type of will is commonly referred to as a pour-over will. You should consult with a qualified estate planning attorney to assist you in the preparation of a living trust, your will, and other estate planning documents. Also keep in mind that your choice of trustee is extremely important. The trustee's management of your living trust assets will not automatically be subject to direct court supervision. What can a living trust do for you? It can help you ensure that your assets will be managed according to your wishes, even if you become unable to manage them yourself. In setting up your living trust, you may serve as its trustee initially, or you may choose someone else to do so. You can name a trustee to take over the trust's management for your benefit if you ever become unable or unwilling to manage it yourself. And at your death, the trustee, similar to the executor of a will, will then gather your assets, pay any debts and claims and any taxes, and distribute your assets according to your instructions. Unlike a will, however, this can also be done without court supervision or approval. So, should everyone have a living trust? Not exactly. Whether or not to create a trust is a personal decision. Young married couples without significant assets and without children who intend to leave their assets to each other when the first one of them dies do not necessarily need a living trust. However, if a couple should die in a common accident or shortly after each other without a trust, their estates may be subject to probate proceedings. Other persons who do not have significant personal assets, for example, any assets less than $184,500, and have very simple estate plans also do not need a living trust. Finally, anyone who believes that court supervision over the administration of his or her estate would be beneficial should not have a living trust. The greater value of your estate, particularly if you own real estate, the greater the benefit of a living trust. And having a living trust could be important in the event of an accident or sudden illness. What are the disadvantages of a living trust? Because living trusts are not under direct court supervision, a trustee who does not act in your best interests may in some cases be able to take advantage of you. By contrast, in probate proceedings, for assets passing under the terms of a will, direct court supervision of an executor reduces this risk. In addition, the cost of preparing a living trust in some cases is higher than the cost of preparing a will. However, it depends on particular estate plans. The difference in cost may not be significant if the estate plan is complex. Also keep in mind that a living trust can create additional paperwork in some cases. For example, lenders may not be willing to lend to a trust and may require a real property be taken out of a trust before they will agree to loan on that real property. So if you have a living trust, do you still need a will? Yes. Your will affects any assets that are titled in your name at your death and are not in your living trust or some other form of ownership governing the disposition, for example, a joint account or a pay on death account. If you have a living trust, your will would typically contain a pour-over provision. Such a provision simply states that all assets should be transferred to the trustee of your living trust after your death. This does not necessarily mean, however, that your beneficiaries can avoid going through probate proceedings for these assets. So who should draft a living trust for you? A qualified estate planning lawyer can help you prepare your trust, as well as a will and other estate planning documents. You can find qualified lawyers by going to any lawyer referral service certified by the California State Bar.